Welcome to the Leaders in Innovation Series, the Technology Management Program. Today we'll be discussing the implications of the recent Supreme Court ruling, Merck and Integra, and the safe harbor considerations related to that. We're very fortunate this morning to be joined by some experts in the domain, notably Vern Norville from Wilson Sonsini, and Jeffrey McKinney from Shepard Mullen, Sig Gutman from Amgen, and very pleased to have our moderator today, Cheryl Mills Englander from the Office of Research here at UC Santa Barbara. So Cheryl, if I may, I'd like to pass the floor to you. Thank you very much.
Well, welcome. Is this on? Okay, yes. We're delighted to see everybody here so early in the morning on what I hope to be a very engaging discussion. Again, my name is Cheryl Mills Englander, and for the purposes of this panel, what I do is I oversee the intellectual property licensing activities that we do at UCSB when our faculty and students create, through their research, inventions or copyrights of potential commercial value. My office tries to find companies that will adopt these technologies and turn them into products that will benefit the public at large. So that's a little bit about who I am, but I wanted to sort of introduce the context of this case decision. There are some potentially unsettling shifts in patent law on the horizon that may present challenges to both universities and early-stage companies alike. Some of you might have been reading about, for example, the Patent Reform Acts that's currently before Congress that might move the country for the first time to having the inventor who is first to file get the patent rights rather than first to invent, which has been historically the standard we've used. And it's also poised to limit the use of continuation in parts, which, as those of you with early stage companies know, are really critical to both universities and companies to protect the patents that are the result of ongoing and more unpredictable basic research. At the same time, in 2002, the U.S. Court of Appeals decided Duke v. Mady, and in that decision, they suggested that some university research may be commercial in nature, calling into question the reliance on the philosophical inquiry exemption to patent infringement, and that certainly caused quite a reaction in both the university and the company communities. So in this context, on June 13th, 2005, the Supreme Court of the United States decided Merck v. Integra, in which they supported the ability of companies to use patented inventions in preclinical research, even if the results of that research aren't ultimately included in an FDA submission. Now, the question before the court concerned a specific exemption to patent infringement, which states that it would not be an act of infringement to use a patent invention solely for uses that are, quote, reasonably related to the development and submission of information under a federal law which regulates the sale or use or manufacture of drugs. The court held this exemption may in fact allow the use of a patented invention for experimentation of drugs that are not the subject of FDA submissions, or the use of patented compounds in experiments that are not ultimately submitted in an FDA submission, as long as there's a reasonable basis to believe that those experiments or that compound would work at the time those experiments were embarked upon. Now, there is a footnote in this decision which clarifies that, or attempts to clarify that a research tool was not involved in the litigation. It was peptides that were involved, and that the court was declining to opine about how the exemption would relate on the use of actual research tools in preclinical studies without securing a license from the owner of those research tools. But the biotech community is still expressing concerns, and it's still unclear whether this decision might open the door to the use of research tools and then claiming the benefit of the 271E1 exemption. So this is just a little bit about what the case we're discussing is about. I will leave it to my esteemed colleagues to maybe put the business and the legal perspective upon this decision. And I must say that I'm as interested to hear their discussions as all of you are. But before we get too much farther, I should probably introduce who you're going to be hearing from. Our first speaker will be Jeffrey A. McKinney, who took his law degree at Stanford Law School. Prior to entering law school, he was actually a medicinal chemist at Zeneca Pharmaceuticals, who's now AstraZeneca, where he performed research related to the amelioration of stroke and manic depression. I think I know some people at the campus who might have benefited from your research. He holds a PhD in organic chemistry from Ohio State and was an NIH postdoctoral fellow at Stanford University. Previously, Mr. McKinney was intellectual property counsel at Alexia Molecular Delivery Corp., an early-stage company with a focus on drug delivery. So I believe he will bring a very good perspective on the case decision with his background. We also are pleased to have Vern Norvell, a partner at Wilson, Sassini, Goodrich, and Rosati, where he leads patents and innovation counseling practice. Before joining the firm in 2003, Vern was the general counsel and corporate security of Perligen Sciences, a startup biotech company that scanned the entire human genome for important therapeutic and diagnostic products. He's also was an early employee and senior vice president of a company I believe we all know, a little company called Affymetrix. So welcome. And finally, we are pleased to have Zygmunt Goodman, a patent attorney who is currently senior patent litigation counsel at Amgen. Prior to joining Amgen, he was a patent litigator with Latham & Watkins, and he's litigated patents, trade secrets, licenses, and antitrust in diverse technical areas, including biologics, small molecule therapeutics, molecular biology, immunology, blood filtration systems, and vehicle crash sensors. An odd departure from his other work. He completed his undergraduate studies in biochemistry at the University of California at Santa Cruz. And he's also worked as a chemist at the IBM's Almaden Research Center. So please join me in a warm welcome to our invited speakers. And without further ado, I will turn the microphone, so to speak, over to Mr. McKinney.
Great. Thank you, Cheryl. In my short talk, what I'd really like to highlight is that Merck v. Integra, the Supreme Court case, has stimulated a lot of divergent views. There are as many unanswered questions as there are answered questions. And to just go through some of the commentary that is already out there. Harold Wegner, who is a very prominent patent attorney and an expert in U.S. patent law, has said regarding the case, the court emasculated much of the patent rights of the pharmaceutical research tool industry in Merck v. Integra. This is in contrast to the director of OTL at a top 10 university who, in a private communication, told me, we don't worry about Merck v. Integra so much. We don't think it's going to have any effect on us at all. In a recent publication from Mauricio Flores, who is the fellow who represented Integra before the Supreme Court, he wrote, while it is hoped that this ruling may speed the development of new medical treatments, a number of questions still remain after the Supreme Court's decision. Last week I was down in San Diego and I talked to someone at a prominent venture capital firm. This person told me investing in platform companies in view of Merck v. Integra just became even less attractive. A couple of weeks ago, I spoke on Merck v. Integra at another university, and at this university I was told that 2 weeks after Merck v. Integra was decided that a major pharmaceutical company initiated a procedure to terminate a license with them in view of the case. And that they were now looking for strategies on how to deal with situations of this sort. One of the things I'd like to point out in view of this discussion is people, I hope, will understand the difference between advocacy and fact, is that it's the job of company representatives, and that includes service providers such as me, to advocate for clients. So that oftentimes a lot of the confusion that you're going to hear will be the result of advocacy positions and not, when you're dealing with a case such as this and there's so much gray area, there is a lot of room for people to take positions. Again, these positions that they can take will be in view of the clients whose interests that they are serving. Therefore, if it's possible for people to dissociate advocacy from the actual factual statements of the case, I think that they will be well served. So that's the end of my portion. Thank you.
Thank you. And we are looking at shorter presentations because we really want to encourage everyone to ask their own questions at the end of this panel. So without further ado.
I'm Vern, and most of what I do in my career is help start small biotech companies, diagnostics, pharmaceuticals, that sort of thing. And most of what I deal with day to day are getting small companies financed and sometimes representing investors in looking at small companies. So we have a few months, I guess now, of history already under our belt in looking at companies from both sides of the equation, from the venture capital community. So I think that my perspective is right now is the sky is definitely not falling. I think the most important thing to keep in mind with the life sciences industry right now is we live in an incredible time. The genome has just been sequenced, and people are really, for the first time, just beginning to understand biology in a first order of magnitude. Healthcare is a very important thing, particularly with an aging population. So nothing is going to change the fact that there's going to be incredibly valuable products come out of the science that's going to be done in the next few years. And people understand that great value will be created and are still very, very much investing in that. So that's really the big picture story of where life sciences is right now. And people shouldn't worry too much about whether life sciences industry will fall off the side of the planet. In fact, VC financing for life sciences companies in the fourth quarter last year, for the first time ever, exceeded technology companies, if you include medical device and biotech companies together. The mood amongst venture capitalists that I deal with is extraordinarily upbeat for the right companies. Not so upbeat for other companies, but for the right companies, it's very upbeat. You see venture capitalists jockeying to put money into deals as opposed to throwing good deals away, and so forth. There's a small dark cloud out there, which is the public market for small companies is still not great. There's not a lot of companies going public, but that certainly hasn't slowed the enthusiasm for early stage companies. That said, right now the flavor du jour for the investment community for life sciences companies, what they're looking for are late stage drug products. The second thing they're looking for, interestingly, is diagnostics. That, I'd say a year ago, was not a business model that was terribly financeable. But I think there's starting to be a recognition that as we understand the genome, personalized medicine will become a reality. And so those kinds of companies are starting to be funded. And for reasons that are largely, I believe, business-related and not Merck v. Integra related, they are still very skeptical about a tools company kind of model. Although I have to say, if you have a tool that's an incredible, potential Nobel Prize-winning invention sort of thing, you are going to be very well financed and in the middle of a VC feeding frenzy still. So you keep in mind the average story of how a company starts is you have the average story from my life is a professor from Berkeley or Stanford or some UC university walks in, maybe from Scripps, someplace like that, and they want to start a company because they have an exciting technology. The way they do that is they go out and they talk to VCs, they pitch the idea, and the VCs in many ways help them get started, but they look over the company very carefully and have consultants and lawyers and so forth look at the thing very closely. Now, patents are a very important part of that value equation. When they're sitting there talking about what is the value of this company, there is no doubt these days, in life sciences at least, that the patents are very important. It's my impression that many of the venture capitalists these days, I'd say there's a lot of VCs out there that are probably better patent lawyers than some patent lawyers I know. And they look at this stuff very carefully. It's no joke with them. I would say in the early 80s, they didn't really understand, investors didn't really understand IP. Frankly, a lot of stuff probably got slipped past them, but that doesn't happen today at all. They hire sophisticated lawyers, and they're probably very sophisticated on their own account. So they go through the patents very carefully, and they definitely think about things like Merck v. Integra in their value equation for a company. There's another kind of I'd say that a very prominent kind of company that's coming out of this actually is called a virtual company. It's, 2 or 3 folks that are scientists, and they don't really start a big organization and hire lots of people. What they do is they have their clinical trials contracted out, they have their medicinal chemistry contracted out, they have animal studies contracted out, and they run it as a virtual company. Now, there's a fair number of these going on, and it even more focuses on the IP equation, because really when you have 2 folks and a stack of patents and that's it, obviously the stack of patents is going to be vital in that. So I'd say it's even becoming more vital as you start to see these virtual companies start to become prominent in their business model. So when you look at those 3 business models, biopharmaceutical, diagnostics, and tools, the investor community right now is, Merck v. Integra is not playing any role at all in the most prominent kind of company now, which is the biopharmaceutical drug model, or in medical devices. It's just not really a factor in the largest part of the financing equation. However, there is that tool model, and there are those very, very successful companies that are still being financed that way. I would say right now that the investor community is not saying the sky is falling, at least yet. I'd say that there is a fair bit of worry about some of the language in the case. If you take some of those paragraphs out of context in this decision, you could come to the conclusion, I could imagine, as Jeff had discussed, that their tool company models are not going to be successful anymore. But on the other hand, there's a very clear footnote that goes the other way. I also think there's another point that really isn't dealt with, which is if the Supreme Court was to ever say tool patents are not enforceable in any kind of clinical research, I really wonder whether there wouldn't be a legislative solution to that. The life sciences technologies are very important to our country and our economy and healthcare and so forth. And if there was to be such a decision in the future someday, I think that probably there would be enough people screaming bloody murder that there might be a congressperson or 2 that would come in and say, wait a minute, that's not what we intended when we passed this law. We're going to go back and clear things up. So even if that happens, I have a sense that many of the investors feel that it would maybe be fixed if the court was to go the wrong way on that. Right now the VCs are very cautious in the tool model area, tool business model area. I don't think that that's driven primarily by Merck v. Integra, but it sometimes is used as rationalization for their skepticism about that kind of a business model.
Thank you. And as a response to the comments, I'll defer to Zygmunt Goodman.
Well, I wanted to focus a little bit more on the legal issues presented in Merck v. Integra. And just by way of background, essentially what, in 3 words or less, what the case was really about was just Merck was accused of engaging in infringing activities during some preclinical activities that were undertaken by Scripps on behalf of Merck. And Integra argued that those activities infringed certain Integra patents. And as a defense to those infringement claims, Merck argued under 35 U.S.C. 271E1, which is this safe harbor provision that everyone's been discussing, that those activities were exempted by that statute from rising to the level of an infringement. And so the real question during the course of all of the litigation was, did the activities that Scripps engaged in on behalf of Merck fall within or outside the scope of that exemption? And what Integra tried to argue, well, of course, Merck argued that those activities did fall within the scope of the exemption. And Integra was arguing, really trying to create a bright line rule by saying that the scope of the exemption did not cover preclinical activities, but only clinical activities. So what the Supreme Court was really trying to address was, given this bright line argument that Integra was promoting, did the Supreme Court really agree that there was some bright line in terms of the types of activities that may fall within the scope of the exemption versus the types of activities that may fall outside of the exemption? And at the end of the day, the Supreme Court, not surprisingly, I think, took a sort of middle-of-the-road approach, where they essentially declined to provide the boundaries around the exemption. They didn't want to provide any specific bright-line tests that anyone could use to determine whether they fell within the exemption or outside of the exemption. But instead, they created a test that really raised this issue to a factual issue, and essentially made it so that all of you will decide whether certain activities that are accused of infringement in the future fall within the exemption or outside of the exemption. And it all boils down to a statement that the Supreme Court made. I think this is a relevant statement of the test that was promulgated by the Supreme Court. And this is a quote. The Supreme Court said, "The use of patented compounds in preclinical studies is protected under 271E1 as long as there is a reasonable basis for believing that the experiments will produce the types of information that are relevant to an IND or an NDA." Now, I can't sit here today and tell you what that means, because again, the way this is all going to play out is that people who are accused of infringement will say that their activities fell within the exemption because they had a reasonable basis for believing that the experiments will produce the types of information that are relevant to some regulatory submission that they were making. And the patentee will argue that there was no reasonable basis for that belief, and the jury will ultimately decide the issue. So there is no bright line rule that says this kind of activity is exempt, or this kind of activity is not exempt, or this kind of information is exempt, or this kind of information is not exempt. There are going to be arguments on both sides of the table, and it's a factual issue that juries will ultimately have to decide. So your guess is as good as mine, what the contours of that test really are.
Thank you. And now I think what we'd like to do is we'd like to open up the floor to ask the questions that you have concerning this case decision and its effect on early-stage biotech companies. Do we have any questions? How about?
So actually, just based on what you were saying, thank you.
Is this on? Is this on? All right. Based on what Sig was just saying, then will the juries that start making these kind of decisions early on have any sort of basis? How should I say this? Will those decisions have any sort of basis later on? So if they decide that in this case there was infringement, or there was some sort of it didn't fall under the exemption, will those people then later on say, well, based on this sort of experiment that was similar to a case that was tried earlier? Is that clear?
Yes, and generally that's what happens in litigation. Lawyers will always try to draw parallels or distance, the cases that they're presenting to the court. They'll either try to draw similarities or distinguish previous cases. And so you will see people, to the extent a jury, for example, finds that certain activities fell within the scope of the exemption, you'll see people accused of infringement trying to draw similarities between their accused acts and the acts that were found to fall within the scope of the exemption, draw those parallels and say, well, these acts have already been found to fall within the scope of the exemption. And similarly, patentees will say, well, these acts have already been found by juries to not fall within the scope of the exemption, and they look a lot like the kinds of acts that the accused infringer in our case are undertaking, and therefore, you should find that those acts fall outside the scope of the exemption. So that's generally how people argue application of the law to specific facts.
So rather than the Supreme Court making the decision early on, it seems like the jurors in the first few cases are going to be setting the precedent for future cases?
Every case can set a precedent for future cases.
I'd like to follow up with one practical limitation about that, which is I would say that on average, if you were able to get inside the conference rooms where decisions are made about whether to sue someone or not, on average, it's at least been my experience that if someone really is just experimenting with a compound, on average, people don't sue over that. So it may be a long time before you hear about these decisions, because it's not very often that somebody decides to sue someone when they see that someone is just doing experiments with their compound. I would venture to guess that Lipitor or Viagra or any of these compounds, these companies probably see people doing experiments with their compounds on occasion. And most of the time, they just don't sue them because there's no real value to be gained by stopping those experiments in most cases. And certainly when it's an academic, in a university setting, again, in almost all cases, a company will take a pass on that. Most companies just don't sue the University of California or Stanford for scientists doing experiments on the bench. So there is, I think, a practical limitation to when you're going to see those cases coming out. Ironically, I think that they probably will come much more quickly in the tool area to clear up this part of the case that the court said they weren't dealing with. So it's somewhat ironic. There are a couple of ironies in the case. One is the part of the decision that the court really clearly addresses are cases that don't come up very much, and the part that they didn't address now has created a whole new fear and anxiety that no one really worried about before, and now the tools companies are worried.
Actually, I'd like to follow up as well is that there are a couple issues. One, I think you have to understand the historical context, is that the Hatch-Waxman Act was passed in 1984. That's when 271E1 came into being. The district courts, this was litigated in the district courts for the next 20 years. The problem was that the law in Massachusetts was a lot different than it was in the law of than it was in Northern California. There had to be some sort of rectification or consolidation of the law, so there was a central position. It took 20 years for that to happen. Now, in terms of what Mr. Gutman read as the holding, there was one key phrase that was left out that's going to be the source of the litigation, which is the Supreme Court. If the Supreme Court had limited these activities or the application of the statutory experimental use exception to the case at hand, that would have been fine and it would have been clear, but that's not what they said. What they said was the experimental use exception covers at least this, which means that it is an open-ended question. Again, it would have been good and fine law if they had left that phrase out, but they did not. And so that's going to be a source of confusion, and the real issue then is it going to take another 20 years to sort this out? And again, I don't think the sky is falling, and I think that's an extreme position. But I think from what you can gather from what we've already said is some sort of uncertainty has been introduced. And when uncertainty has been introduced, valuation is affected. It may be affected in an incredibly small way. It may be affected in an incredibly large way. And those are the factual issues that become important.
Do you think, just to follow up on that, due to the uncertainty, it's almost an argument that the licensing activities will stay the same because the companies will be seeking contractual permission as a protection against the uncertainties?
I don't know, but here's a practical situation that I'd like to throw out to Vernon Sig, and this is the one that I've thought about. In view of the law, if I'm a major company and I'm looking at potentially infringing a patent of a small company in this area, if I know that I can go to a major law firm now and get an opinion that the patent is unenforceable because there is so much uncertainty with respect to this case, then is the worst that I'm ever going to do is at some point in litigation, even if I lose, a theoretical negotiated license anyway, because I no longer have to worry about treble damages in the case of willful infringement. And the other thing that you throw on top of that is this is not the only area of law that's converging. You also have the area of law with respect to damages in patent infringement cases, which is also a hot changing area right now, where there's a dicta from the Federal Circuit that says that they may not allow reach-through royalties. So if you look at the convergence of all these areas of law, why wouldn't large companies simply use their muscle in these types of licensing negotiations?
I have to say, I think, I don't represent big companies, I tend to represent small companies, but I have the sense that both big companies and small companies, even before this decision, took the position that, hey, if I'm just doing an experiment with a compound, yeah, they'll sue me, and but what's it worth? And it's not even worth getting an opinion because the damages wouldn't add up, even if trebled, to what it's going to cost me to pay some lawyer to study the darn thing. So I think there was a fair amount of ignoring these patents in this setting anyway, and I don't know, but I would guess that. On the other hand, it is the case still, and it's very important to keep in mind that if somebody has a patent on one of these compounds, if it comes through that research and ends up being the commercial product, this decision doesn't change a darn thing there. So if somebody has a patent on a compound and it ends up being the one that a company moves out into the clinic and into the commercial context, you can still sue them and stop them. And that's where the value is. It's not so much in the experimenting and so on and so forth. I guarantee you that if Lipitor or Viagra is being used in a experiment by some company or university, Pfizer is going to put a lot less value in that than if somebody goes out and starts to sell Viagra. You probably will definitely get a call from Pfizer if you start to sell the molecule. So we have to keep that all in context. I think there was a fair bit of that going on in the back rooms anywhere where people ignored this sort of thing.
Would you like to provide some brief comments before we move on?
Just briefly, I think that it's important to distinguish between liability for infringement from damages, which is what Jeff and Vern are talking about. And the Supreme Court decision really just focused on the liability issues. That is, did the activities that Merck engaged in infringe by virtue of falling outside of the scope of this 271E1 exemption. The damages issue is separate and apart, so that if Merck is ultimately found to be infringing, that is, their activities fall outside the scope of the exemption, then a jury will have to decide to what extent Integra was damaged. And that's another issue that all of you will have to decide in future cases of this kind.
I believe the lady in pink had a question.
Jeff, in your opening comments, you said that somebody had reneged a license that they had with an organization. Does that mean that they no longer felt, because of Merck versus Integra, they no longer felt they needed a license to use the technology they were using?
That is correct. I didn't ask permission to quote the people. I won't say specifically who it was, but that is exactly the situation. And it's a situation that's much more close to the Merck v. Integra facts. I think one of the things that, again, that Vern is talking to, or has been talking about, is that for Merck v. Integra, it's very important to look at where there's going to be an effect. The place where there's likely the largest effect is where you're dealing with an invention that is only used in the research phase of a drug discovery program. I mean, I don't think anyone is arguing that it has any effect once you hit the commercialization stage. The fact of the matter is that for these inventions that are mostly going to arise either from biotechnology companies, early stage pharma companies, or universities, this is where the question really lies, is how broad will this go? Also, in terms of what Vern was saying, in terms of experimental use, I mean, there is an interplay between what's called the statutory experimental use exception and the common law experimental use exception. And this is an interplay that really has come into question with respect to the Supreme Court's decision. In terms of the experimental use, I think that Cheryl referred to this earlier, is that it has always been the case since 1806 that if you're really using a patent invention for philosophical inquiry to determine what the boundaries of the invention are because the disclosure of a patent application is not complete, then that is an act that is exempt from infringement under common law. That's a doctrine that's tied up also with something called the de minimis non curate lex, which means that the law does not concern itself with trifles. So these are the two sides of the experimental use exception, one statutory, one common law. And how these two fit together is going to be a source of litigation in the future.
If you could wait for the microphone. I'm sorry. Okay.
Please. So let's say I'm a tool company and I invent a tag molecule that aids in the fractionation and then, say, Merck they read about my patent, they use my molecule, and in the use of that, experimental use of it, they discover a new drug. Then, am I understanding this correctly, that my company now has no claim against Merck for the invention of that new drug? Or is it only in a case where they experimented with it and learned how to produce something else where am I losing my value as a tool company in this process?
That's exactly the question that isn't answered. And so if you had a molecule, let's pretend like PCR was a very important invention in the life sciences industry. So it's an interesting thought experiment to imagine PCR was invented today at the University of California, for example. And that's the thought experiment that people don't have the answer to, is what if PCR was invented today? Would the University of California be able to enforce that against drug companies when they're using it in their research to look at, say, let's say the genetics of a disease and the interaction of molecules with a particular gene and so forth? And that's the question that the court said specifically they're not addressing. But as Jeff pointed out, there are a couple of places in there, and there's another one actually in addition to what Jeff said, that would appear, if you read between the lines, many people believe, to say that the University of California or whatever institution invented that would not be able to do anything about it because it would be in the clinical development process of some sort in many cases. So that's the question that's just really open. I really do feel like that. I must say that one of the VCs I heard said, well, it would be fixed if it was a problem. If PCR was invented today at the University of California and the Supreme Court said UC can get no value from that, I have a feeling there'd be some congressperson that would step up and say, that's not going to happen here. And who knows, maybe before even such a decision was to come out, perhaps some congressperson will take it upon themselves to make sure that that's not a problem. So it makes so little sense that you almost have to believe that something will happen to make sure it doesn't happen.
I mean, in contrast to that, and again, I don't believe the sky is falling, but you have to look at the historical context of the Hatch-Waxman Act in 1984. That act was specifically passed in response to a case called Roche v. Bohler, where you had a generic pharmaceutical company, Bolar, that was arguing that Roche got a effective extension of its patent lifetime because it could not conduct trials for an FDA submission for an ANDA prior to expiration of Roche's patent, which then gave Roche an effective 2-year extension. And so I do believe...
If I could jump in, ANDA would be a generic that they wanted to prepare to hit the market at the expiration of the patent?
That's correct,
okay,
yes. Right. So again, with respect to legislation, I think there's at least 2 points. Is that if you look at Bolar still got crushed. So it may be that people who, the first case that's ever going to cause legislation to be enacted, that first person really is out of luck anyway. The second aspect to that, I think, too, is that you've got to look at lobbying organizations. And it is true, at least I believe, that the big beneficiaries of this case is major pharma. And so what is the incentive? If you're looking at the various lobbying organizations and who has the most money to lobby, what really would be legislation that was enacted? How would it be, and how hard is it going to be fought, and how long is it going to take to enact? I don't know. I think those are open questions.
So the UC system is required by law to patent, but they're required by law not to lobby. Is that correct?
I don't know.
Well, if I can address that, we're not required by law to patent. Our faculty members are under obligation to disclose the technologies. Patents are state assets of the state of California, and we do have a very clear mission placed upon us, both through federal BIDOL and through the state, to use tech transfer and licensing as a mechanism to get our research results, which might sort of reside in dusty archives otherwise, actually into commercial products by using licensing as an incentive for a company to adopt those discoveries and to translate them into commercial products. And as far as lobbying, yes, we do maintain a neutral position whenever possible, because we are a public university.
So Stanford will have to do that part.
Well, no, I mean, I think it's a little more complex, and it's not, frankly, my general area. We certainly do governmental relations. It's important for Congress to understand the benefits that a public university provides and a private university provides. Whether it rises to lobbying, most likely not. We try to be a little more conservative, but we do have active governmental relations. So hopefully that places it in context. When we do have a research tool, what we're looking for is to use the patenting process, to use the licensing process, to incentivize, whether it's a startup company or a big pharma, to incentivize someone to go out there and translate our faculty's research efforts into something that'll actually benefit. And probably one of the best examples in bio, I think, is anyone who has a young child has had a hepatitis B vaccine. That was from UC San Francisco. And I think it's very doubtful if a company was not promised exclusivity. I think it's doubtful that drug, that vaccine would have been developed as well and as quickly as it has. So that's a great sort of easy example of why universities are in the technology game. Unfortunately, I wish I could say we make tons of money on it, but
Well, there are a few examples.
There are a few
university.
examples. When you hit the jackpot, you do well.
Cohen-Boyer was a good one.
Yeah.
And I think UC benefited from that, and I think society's benefited from that as well, hugely.
Yeah.
And so, again, another interesting thought experiment of what would have been the impact with Cohen-Boyer had the court gone and made a decision that is more extreme on the research tool area. I'm not sure, actually. I don't think it would have been pretty.
Right, but then again, if you look at the Boyer-Cohen patent, if you look at the Stanford licensing procedure that all their tests set up, Boyer-Cohen was never litigated, and people believe that it was never litigated due to the fact that what they did is they set an upfront licensing fee that was exactly the same as what it would cost to get an opinion on the patent with respect to invalidity or infringement. And they did that specifically so no one would challenge the patent up front. So again, there is this interplay in licensing, but again, I think people early on were worried what would happen if Boyer-Cohen was litigated.
There's another little dark cloud on the horizon, just to paint another little dark cloud for the tools companies, which is there was another court decision recently that said basically you can run experiments outside of the United States and then just import the data and with no problem. And so not only are you facing the situation of our research tools patentable at all, but there is also the problem that at the end of the day now the courts have said even if they're enforceable, all you have to do is set the thing up in Canada or Mexico, and then just email the results of the experiments in, and it's a free pass to go with a research tool patent. So there's some reason to be concerned right now.
You started to touch on a subject dear to my heart, and that is that everything I've heard so far is kind of myopic in terms of it's U.S.-centric. Most of the world markets outside the United States, and there's such a divergence between patent process overseas and first to file versus first to invent. The process that we're going through here now, I mean, we're looking at China right now and trying to scratch in our heads saying, do we really believe that there's going to be any real patent protection in China in my lifetime anyway? I'd like to get your opinion about that because, see, we're all caught up in worrying about specifically what's happening here in the U.S. alone, but in fact, drug development's moving overseas. And part of our litigious society is causing that, but also the fact of the matter is that there's a lot of smart people popping up in places in India and China and other Eastern European countries who are saying we'll do drug development, and we don't have to deal with the legal system in the United States. And so I'd like to kind of get you guys' thoughts on that, because as a company that's developing drugs and now dietary supplements for the world, I'm very concerned about what the cost is and what the activities are required to try and play the game on a global basis.
So when the VCs or the investors are looking at that, you're absolutely right. Very often now they're thinking that more than 50% of the value equation comes from outside the United States. And roughly speaking, today they sort of assume it's Europe and U.S. sort of equal, and Japan right up there. But I think I saw a statistic the other day that it's the number of insured people in China will very quickly or very soon surpass the number of insured people in the United States. And that's where the value comes from, is frankly insured people. So China will become very quickly a very important player. That said, again, as to drugs, it almost doesn't matter which way this decision comes out, as long as there is good protection for drugs in a given country. And India, for example, I think has recently made some moves that look like they're going to get more in line, such that drugs are well protected and so forth. So I don't think that even if it goes one way or the other on this issue, in one country or the other, I don't think it changes the value equation that much for a drug company, a biopharmaceutical. Again, I think that you're absolutely right. It's total wild card as to what will happen in these other countries as to this decision as it is in respect of tools. And we have no idea right now. We have no idea in the U.S., and we have certainly no idea in other countries how this will pan out.
Do either of you wish to make a comment on this?
I guess I'm more prepared to talk a little bit about the experimental use exception, the fact that it does exist in other countries. There's a statutory experimental use exception in Germany. There's one in Japan. They're very, very similar to, it's my understanding that they're very similar to essentially what was expressed in the Federal Circuit's opinion on Merck v. Integra, which is they were specifically enacted to bring generics onto the market faster. And so I think it's a much more limited exception. One of the interesting extraterritorial effects I think you can think about, again, they don't relate to once drugs are commercialized. But the problem is what happens if you get in a situation where people are using patented technologies in other countries, for instance, where this experimental use exception may not apply, but then they discover a drug and they import it back into the United States. Again, part of Hatch-Waxman, or I guess it was part of Hatch-Waxman. It was enacted in 1984 as a Process Patent Act, which says that if someone uses a method that's patented in the United States in a foreign jurisdiction and then imports that product in the United States, the act of importation is an act of infringement. Now you have a situation where someone could actually be using experimental procedures in a foreign country, and those experimental procedures would not constitute infringement in the United States. Then what do? Has this extraterritorial provision of the Process Patent Act been affected? And I'd say probably yes.
If as Vern suggested, people start engaging in outside the U.S. activities in order to circumvent the implications of the, for example, the exemption that we're talking about, then again, that might be something that Congress would have to address, because obviously the U.S. doesn't have the authority to manage what's going on outside of its borders. So it's not something that a U.S. court is going to be able to address in terms of providing the means of addressing activities that are conducted solely outside the United States. And so that might be another issue that Congress would have to address from a public policy standpoint.
Any more questions? Yep.
I'd just like a little more clarification on sort of the scope of what this covers in terms of the type of IP and the definition sort of preclinical research, if there's a way to kind of narrow down where this could affect tool companies. I know it's sort of was left as an open question, but can we kind of narrow it?
I don't think so. I mean, sitting here today, I wouldn't know how to respond to that and suggest any ways that it would narrow it, just simply because, as a matter of law, the Supreme Court determined that it's an open-ended question. So, the Supreme Court really just declined to give any sort of structure to the exemption beyond that test that I quoted. And juries will just have to decide whether someone had a reasonable basis for believing that the data generated in various experiments are related to the development and submission of information to a regulatory body. And beyond that, there really is very little that the Supreme Court said that provides any affirmative guidance to help, for example, research tool companies in terms of predicting whether their activities will fall within the exemption or outside of the exemption.
I could address that a little bit more. I guess in dicta, what the Supreme Court said is the statutory exemption does not flow down to basic research. And again, my guess, if there's litigation in this area, it begs the question as to what basic research is. What I did was I went in and looked for, because they're in the government briefing or the government brief on the case, and I don't think it was mentioned in the Supreme Court opinion, but the idea is that I believe the Supreme Court said everybody knows what basic research is. The government brief said that we have guidance in this from the FDA. So I went back and I took a look at what the definition of basic research was with respect to governmental agencies. Consistently, the definition is basic research is research having to do with philosophical inquiry. Okay, so that means that it cannot have any sort of commercial end at all, and basically what they've done is they've said that we've stopped at the common law experimental use exception, will not extend it further. As far as other guidance, I think if you look at the holding of the case and how the facts underpin it, I think the idea was that the statutory exception went back to preclinical studies because those were preclinical studies where the information sometimes is submitted to the FDA. I think if you're looking for guidance, and I can't say that this will fully help you, but what I would do is I might ask the question as to whether or not that the information, if it is generated from my invention, can generate the type of information that could be submitted to the FDA or has been. If it doesn't generate that type of information, then I might feel pretty good about that. At least I would have a supportable argument and an advocacy position as to why that Merck v. Integra doesn't touch me.
Would you like to make a comment on this?
I think you'll probably be able to get as many answers to that as you ask different lawyers. So I do think stepping back one step, it seems if you had let's say a fluorescent protein that had been invented and was being used in research, perhaps even right in the mainstream of, say, doing studies for looking at how a drug reacts or acts in a particular cell line, for example. Stepping back one step to why this law was adopted, it was intended to prevent people from extending their patent terms on their drugs. And if green fluorescent proteins were being used in basic research or in research even on a drug, it's a little hard to see how a drug patent is being extended in that situation. So, philosophically, I feel like the court shouldn't go that way. But the fact that the court in the Supreme Court made so many sort of broad statements in this Merck v. Integra decision, you have to worry that they would go the other way. So I suspect you'll find as many opinions as you can find lawyers until there's a case.
And how about we do, I'm sorry, one final question I think we need to wrap up. So anybody have a final?
Pursuant to the comments that Mr. McKinney made, the reference you were making, I think, touches on Duke versus Mady decision, which is in the federal court. Can we reconcile that decision with the Merck decision? The courts seem to be saying radically different things.
Well, again, it's my understanding that Duke v. Mady has to do with the common law experimental use exception. I think that if you look at the literature from Mauricio Flores and other people, they believe that that's going to be the source of litigation, is rectifying those two bodies of law. And, I think that people should take pause when they, if you look at the Federal Circuit opinion on this case, you've got Pauline Newman, who arguably is the most prestigious judge on the Federal Circuit, saying that she believes that all of this should be exempt. Everything, every activity should be exempt from infringement if it has to do with research, all the way up through clinicals, all the way through preclinicals, virtually all of that experimental activity should be exempt from infringement due to public policy, that it's simply bad public policy to inhibit drug discovery in any way. But again, I think that those are the two bodies of law that need to be reconciled.